University of Padua for having invited me. I'm going to speak, as you said, about the first two climate litigations launched in Italy. In both cases, the documents have been prepared by Rete Legalità per il Clima, which is a network of legal experts. The first litigation is against the Italian state, and the other, as you said, is against the oil company ENI. I've been working on the case against the state for about 3 years. The litigation has been launched in June 2021 on the behalf of 24 NGOs and about 180 individuals, including many minors. The first hearing will take place on the 14th of December. The road to the litigation has been prepared by a campaign. The name of this campaign is Giudizio Universale. This is not a case before an administrative court because we will not challenge a specific law or a specific act of the state, but rather the poor efficiency of the climate policy of the state. In many respects, this litigation follows the Urgenda case, but of course there are some differences related to the peculiarities of the two legal systems. But in common, these two cases have the kind of the judge, because we will go in front of the civil judge, and the request of the plaintiffs, which is the cutting of emissions. We will not ask any redress, any payment for redress. The summons is structured into two parts. The first part gives an idea of the climate change issue. It talks about the scientific evidences that support the anthropogenic nature of global warming, the climate emergency, the international rules on climate change, with the focus in particular on the Paris Agreement. We talk about the documents that show the Italian state's awareness of the climate change impacts, the documents that show the vulnerability of Italy to the impacts of climate change, and this vulnerability is very serious. Italy is hit very much by the impacts of climate change, such as coastal erosion, hydrogeological instability, desertification, extreme weather events. We talk also about the National Energy and Climate Plan of December 2019. According to this plan, the policies planned by the Italian government will lead to a reduction of greenhouse gas emissions in 2030 of 36% below 1990 levels. We will see that this level is very, very poor. In fact, we have attached to the summons a report from Climate Analytics about Italy's fair contribution to the fight against climate change. Climate Analytics has estimated that in order to limit the increase in temperature to 1.5 degrees, Italy's fair contribution by 2030 should lead to a 92% reduction of emissions. So there is a huge difference between 36 and 92. This percentage, 92%, is obtained taking into account Italy's historical emissions and current technological and financial capabilities, in accordance with the principles of equity and common but differentiated responsibilities that characterize climate law. The second part of the summons has legal content, and it starts talking about the climate obligation of the Italian state, climate obligation that emerges from different sources. Overall, the United Nations Framework Convention on Climate Change and Paris Agreement, and in particular by the connection of these international agreements that Italy has signed and ratified with domestic rules. According to us, the state has bound itself to fulfill a series of obligations, both towards other states and towards its own citizens, as required by different articles of the Italian Civil Code. Moreover, Italy has subscribed all the IPCC reports, and doing so, the Italian state has also recognized the duty to confirm its action to the scientific methods used by the IPCC. And according to us, this is a limit to political discretion. Also because the science in our legal system has a very important rule. The content of this climatic obligation is very complex. It's an obligation to do something, but to do what? Basically, the states have to make the climate stable, maintaining the increasing temperature, and this is a permanent and dynamic doing, mainly of a preventive nature. This commitment, as you can see, not end with a single and limited performance, but it must be continuously pursued and must be pursued within a certain timing. The first threshold is 2030, as required by the IPCC reports. The content of this climate obligation impose to the states the cutting of their emissions. There is no other way. Another part of the summons deals with the topic of fundamental rights that are threatened by the climate change. Some of these rights are recognized in the Italian constitution, others in special laws, others in international treaties. The list includes the right to life, the right to health, to an healthy environment, to family life, to home, to food and water. But, and this is a peculiarity of our summons, among these other fundamental rights, we include also a new fundamental right, that is a right to a safe and stable climate. For us, this is an existing right, which belongs to each individual, and which can be recognized from the cross between national rules, and basically rules foreseen in our constitution, and international rules on climate change. Of course, we have a problem. Such a right is not written anywhere for the moment. It's not written in our constitution, nor in special laws, nor in international treaties. But it should be remembered that in Italy, even the right to a healthy environment is not specifically mentioned anywhere. But judges and doctrine recognized since the 80s this right as a derivation of the right to health. This is possible in Italy. Luckily, our legal systems allows this kind of operation, and we believe that the time is ripe for the recognition of the right to a safe and stable climate, digging it deeply into the right to health. So this new right is a derivation of the right to health in light of the international rules on climate change. The inability of the state to fulfill its climate obligation, as demonstrated by the report of Climate Analytics, generates extra contractual civil liability. And this is recognized by the Article 2043 of the Italian Civil Code, which provides for a general neminem ledere clause. It's an open clause. The liability of the state can also be identified under other articles of the Civil Code, in particular Article 2051, that foresee that everyone is liable for damage caused by the things he has in custody. We have to remember that the state, as a party to the United Nations Framework Convention on Climate Change, is legally obliged to protect the climate system for present and future generations, and it's therefore could be considered as a sort of custodian of the climate system of its own territory. On this basis, the objective of the case is to ask the civil court for a ruling condemning the state to take all the necessary steps to reduce greenhouse gas emissions in order to achieve climate stabilization according to the best available science. so that in this way can be granted the effective protection of human rights. The specific requests that we make, the claimants make to the court are basically two: declare that the Italian state is responsible for the dangerous situation resulting from its inaction in combating the climate emergency, and order the state to reduce greenhouse gas emissions of 92% by 2030 compared to 1990 levels. Because this is the only way to align the climate policy with the long-term targets set by the Paris Agreement. As I told, the first hearing will take place on December, so this litigation, it's only at the beginning. Let's see what will happen. And now I'm just talk about the second dispute that is at a preliminary stage, because in July 2021, the Rete Legalità per il Clima sent a warning to ENI. So there is not yet a litigation started, but only a warning that was sent to ENI, asking it to reduce its direct and indirect greenhouse gas emissions to a level compatible with the long-term target of Paris Agreement, to abandon no later than 2022 any funding for fossil fuels, and to exclude the production of blue hydrogen. We fix a term to ENI, the 10th of November, so we are waiting for the response that up to now we have not received. Basically, in the warning, we attacked any industrial plan, which is very contradictory in several respects. First, it foresees an increase in greenhouse gas emissions. It's unbelievable, but it's really the truth. The industrial plan of ENI clearly indicates that in the short term, it's foreseen not a cut, but an increase of gas and oil extraction. And this will bring, of course, to an increase in greenhouse gas emissions. Fossil production, in fact, from 2021 to 2024 will grow, according to the plan, at an average annual rate of 4%. And this is unacceptable. Another aspect of the plan is the negative aspect of the plan is the timing. ENI will start reducing its emissions only from 2025 on, to arrive by 2030 only at a 25% reduction of its emissions compared to current level. The bulk of decarbonization is therefore postponed after 2030. So in the coming years, basically the plan of ENI is doing nothing. Another point is that the foreseen cuts are not real, but in part are only hypothetical. ENI has declared that the objective of zero net emissions that will be reached in 2050 will be reached partly thanks to reduction of emissions, but partly through mechanisms that are uncertain, such as emission offsetting projects and the use of CO2 capture and storage technologies. And this part of the plan has a big weight, because it covers more than 20% of the planned reduction. Another negative aspect is the production of blue hydrogen. In order to achieve the decarbonization objectives in the plan, ENI is aiming, as I told, at the production of blue hydrogen, which at the moment is obtained as a result of a technological process that uses gas. And also this part of the plan for us is unacceptable. Another aspect is the marginal use of renewable energies. Investment of any in this sector remains very poor and very marginal. The heart of the business for the next year is still tied to fossil fuels. So we will take action against Eni. We are planning to sue Eni if nothing changed after the time of the 10th of November. And we have also to consider the impacts that Eni has on climate systems, because Eni alone emits more than the whole of Italian states. We are in climate emergency, and in climate emergency, whoever acts to aggravate this emergency is responsible. Mr. Singh correctly stated that 100 fossil fuel companies are responsible for more than 70% of emissions. If we want to combat the climate emergency, we can no longer allow fossil fuels companies to emit whatever they want with impunity. We will wait for the 10th of November and then let's see what happens. For the moment, we are working to build a broad coalition of associations and movements to join us in this battle. You will excuse me if I have not been able to go into much detail, but the time was really short. However, I am at your disposal for any question that you may have. Many thanks.